Good morning and welcome to our first speaker series webinar of 2023, New Year, New Forms. I'm Romeo Arrieta. I'm the Chief Executive Officer of the Marin Realtors. Before we get to today's speaker, C.A.R. attorney Neil Kalin, there are a few housekeeping items I want to go through. This is a webinar, so everyone's muted by default and your camera's turned off. If you have any questions, please type them in the Q&A feature, and we will do our best to get to them throughout the meeting. Some of those questions might get answered throughout the presentation, and if they do, we'll mark them as answered just to save time. As a reminder, if you feel that you missed something or would like to review it later, we'll be sending a recap with any links mentioned in the program, and Neil said that he would be kind enough to share his slides as well. I'd like to recognize our 2023 President, Sylvia Berry, and I will turn it over to her.
Well, thank you, Romeo, and hello, happy Valentine's Day. I want to thank everybody for being here, and special thanks to our board of directors and our committee volunteers for your service. Of course, I'm going to do a couple of thank yous here. I want to thank our 400 or so realtors who together have contributed just shy of $8,000 through our voluntary contributions during dues billing to support Homeward Bound of Marine's effort to end veteran homelessness in Marin County, hopefully by 2024. And this year, we'll continue the speaker series, the in-person general membership meetings, and we will have other education and professional development throughout. Our very first general membership meeting is in person on March 7th at the Embassy Suite in San Rafael. The speaker is our very popular local legal expert, Bill Jensen. Tickets are on sale now. Watch for your Monday rundowns. Please save the date for C.A.R.'s Legislative Day in Sacramento on Wednesday, May 3rd. It's always a very exciting day, and there will be a lot of issues that we'll be watching. We hope to have a lot of realtors there. And now I want to thank our premier sponsor today for her continued support of Marin Realtors and this event, reverse mortgage specialist, Hikaru Rasuli, of Mutual Mortgage Omaha. Homa, go ahead.
All right. Thank you, Sylvia. Good morning, everyone. Happy Valentine's Day. I'm Hikaru Rasuli. I'm a reverse mortgage specialist with Mutual of Omaha Reverse Mortgage. It's my pleasure to be able to sponsor and be here. Thank you for your trust. Thank you for all your questions and referrals that you have made me. I made it to the President Club again because of all your support from last year. And all of you know about reverse mortgages. And if you don't, I'm always having once a month, a great realtor certification course, which is coming up on February 21st. And it's going to be in Marin Realtor newsletter. Please look for it for February 21st. Reverse mortgages are for homeowners 62 years and older to be able to get refinancing if they want to stay in their house and refinance to get no monthly mortgage payment, or get a great line of credit, or imagine showing someone how to purchase their dream home with one-time down payment and no monthly mortgage payment required after that. This is really a great product. It's insured by the government, and I can answer any question that you may have anytime regarding how much down payment they need. Can we refinance for this person? So please give me a call at any time, and I'm always here to help you. Have a wonderful day, and thank you for having me today.
Well, thank you again, Homa. And you will see that I'm running through this pretty quickly because our speaker today, Neil Kalin, has a lot to cover. Please note that he will be answering questions after his presentation. So if you have a question, please write it in the Q&A feature at the bottom of your screen. Neil Kalin of C.A.R. Recently attended a C.A.R. winter meeting. He spoke about a few cases at the winter meeting's Realtor Risk Management and Consumer Protection Forum, and I really enjoyed it. Neil Kalin joined the California Association of Realtors in 1987 and is now Assistant General Counsel. He's the Senior Legal Advisor to C.A.R. Standard Forms Committee. He provides advice to C.A.R. members on the legal hotline and writes many of C.A.R.'s appellate court briefs. Neil is an arbitrator for the American Arbitration Association, and he has served as Judge Pro Tem and a volunteer mediator and arbitrator for the Los Angeles County Superior Court. Neil has earned his Certified International Property Specialist designation, CIPS, from NAR in 2001. In 1982, Neil received his Bachelor of Science degree in advertising from the University of Illinois. And also in 1982, he received his Certificate of Public Accountancy, of course that's CPA, and he graduated from UCLA School of Law in 1985. And I give you Neil Kalin, take it over. Thanks, Neil.
Thank you. It's wonderful to be able to present to your association. I'm glad you enjoyed the presentation at last week's meeting at C.A.R. at the C.A.R. business meeting. And I'm here to tell you all about the C.A.R. December 2022 forms release. So the forms have just been out for just a couple of months now, and some people are still getting used to them. So this is a really good opportunity to find out what's there, what's new, in case you haven't opened up some of these forms recently, as well as tell you about some of the new things that are coming up. So let me share my screen. Here we go. So you see I'm all decked up, you know, at least on a slide for Valentine's Day. I think over the pandemic, I put on a few pounds, so I don't think that vest fits me anymore right now, but we'll have to see if I can get back into it maybe by the end of the year. So again, thank you for having me. A pleasure to be here. Let me tell you what our agenda is going to be like. So we're going to go over some of the changes to the residential purchase agreement, 2 new forms, a non-contingent offer advisory and a solar form. There was one change to all 3 of our counteroffer forms, so I'll quickly go over that. Just a quick reminder of something that we did for the cancellation of contract form. And then we have this whole new suite of forms dealing with buyer representation. So I'm probably just going to give you an overview. My slides go into more detail. And as Romeo said, I'll make the slides available to you if you want some more detail. But I'm going to give you kind of a good overview about buyer representation and why it's important and why we think it's probably more important in 2023 than it's been in the past years. And then one property management form I'm going to go over because it affects more than property managers. It affects lease listing agents, and that's the rental property owner disclosure. You see in the left side kind of the list of everything that C.A.R. did in December of last year. So let's jump right into it. We're going to start with the RPA revisions. As always, whenever C.A.R. makes revisions to the residential purchase agreement, we conform all of our other purchase agreements so that members, when they use a C.A.R. form, they see the same thing in every form. So we made these same changes to our income property agreement, our commercial agreement, our vacant land agreement, our notice of default purchase agreement that we hope gets very minimal use. And then the three last forms, those are ones dealing with subdivision properties. So let's look at some of the more salient and important terms that were changed in the residential purchase agreement. And the first one appears right here in paragraph 3E1, and it has to do with the loan terms. And what do we want to know about the loan terms? Well, what we're trying to figure out about the loan terms is the thing that has changed is from December of 2021, when we made all those major changes to the C.A.R. RPA, we created the grid that's in the first few pages of the form. And in the loan term paragraphs 3E1, what we did was, of course, we kept the amount, you know, is it going to be a fixed rate or an adjustable rate loan? And then when we dealt with points, we had an automatic default for the buyer to pay 1 point to obtain the loan that was specified. Our standard forms committee met, of course, after the form has had a chance to be out in the field. And our members were saying, you know, it's pretty unusual for there to be, what it used to be, it defaulted to 0 points. I apologize, not 1 point. It defaulted to 0 points. And our standard forms committee met and they said, you know, it's kind of unusual to see, 0 points. We're usually seeing something in the field more than that. It may be 1, it may be 1.5, it may be 2. And so the committee went around and around and around trying to figure if they should change the default to a different number, and they couldn't agree on the number. So what they finally came up with is that, well, why don't we just not have a default at all? And when the offer is being filled out and the buyer is making the offer, they can indicate how many points they're willing to pay to get the type of loan that's specified in 3E1. So that's the big change, right? Of changing from a 0 point default to no default at all, which means now there's 2 blank fields that would need to be filled in paragraph 3E1. The interest rate on the loan itself and the number of points that would need to be paid. So that was a significant change right there. Excuse me. There was a slight reorganization of the way that box looked, but that's because we just tried to clean things up. But probably the bigger change here on this page of the RPA is we get down to paragraph 3G3. In 3G3, you see on the lower part of your screen, this is a new paragraph that was added to accommodate what was being done with buyer representation forms, because C.A.R. got rid of our 3 buyer broker forms, replaced them with 1 new form called the Buyer Representation and Broker Compensation Agreement. And as part of this whole re-looking at buyer representation, we realized there may be situations where what the buyer agrees to pay the broker, their own broker, is more than what the seller's broker or the listing broker through the MLS agrees to pay the buyer's broker. And while we don't have to necessarily do anything with that differential, there are times where maybe the buyer just doesn't have the funds to pay that additional amount of compensation, and the buyer might want to ask the seller to pay for that. And can the buyer ask the seller to pay for a cost that would normally be a buyer's cost? And the answer to that is absolutely yes. So you notice paragraph 3G3, why did we add this, little narrow paragraph 3G3? We added it in section 3G. Why? Because if you look at 3G1, that's where the buyer has the opportunity to ask the seller to pay for buyer's closing costs, right? To give the buyer a credit for closing costs. So that is a cost that the buyer has in the transaction. If the buyer has already signed a buyer representation agreement, then the buyer may also have costs in the transaction. And so this is just another opportunity for the buyer to ask the seller to pay. This paragraph has absolutely nothing to do, does not change the listing broker's offer of compensation through the MLS. It's only applicable in 2 situations, okay? There are 2 prerequisites to making this paragraph apply. So one thing I just want to mention, in that 3rd column, that long column there, you notice there's a box before the word seller agrees. So this is an optional paragraph, right? It does not apply in every transaction. It only applies if the buyer has already signed a buyer representation agreement with their own broker. And the other prerequisite is that there is a differential. In other words, the buyer owes their own broker more money than the buyer's broker is receiving from the listing broker through the MLS offer of compensation. Now, one of the items you see there in paragraph 3G3, there's a parenthetical reference to C.A.R. form SPBB. That's Seller's Payment to buyer's broker. And I'm going to show that form in just a second, because it shows how this really works, okay? And that form is really more towards the latter part of my presentation, dealing with buyer representation, but we're dealing with this issue right here in the RPA, so I want to show it up front. So let's deal with that right now. Notice in the bottom right of your screen, it says, you won't need this most of the time, because most of the time, the buyer's agent is going to accept the listing broker's offer of compensation, and that's going to be sufficient to satisfy the buyer's broker. And if that's the case, you don't need to worry about 3G3. You don't need to worry about this extra form that I'm going to show you, the SPBB, right? So most of the time, you're not going to need to be concerned about this. But when you do, it's nice to know that we've got appropriate forms there to help you through the situation. So here is that new form, seller's payment to buyer's broker. And I circled 3 paragraphs here. Paragraph 1 identifies how much the buyer has already agreed to pay their own broker. Paragraph 2 identifies how much the listing broker has offered to pay the buyer's broker. Well, since under the C.A.R. buyer representation agreement, if the buyer's broker receives compensation from any other party, typically the listing agent, then that is credited against the buyer's obligation. If there's a differential where the buyer still owes their broker money, well, then the buyer has the opportunity, does not always have to use it, but the buyer may want to ask the seller to pay for that differential. And paragraph 3 identifies that differential. That's the only time this form would be used. So you look at paragraph 1, you subtract the number or percentage from paragraph 2. That differential is what the buyer might want to ask the seller to pay for. Now, some of you say, well, why wouldn't the buyer always ask the seller to pay for it? And the reason why a buyer may not always ask the seller to pay for it could be because of the market conditions in your area. And the seller may have no incentive to help the buyer pay for the buyer's own costs. Just like the seller can refuse to pay for buyer's closing costs, just like a seller can refuse to pay for repairs that the buyer requests, the seller can refuse to pay for any additional costs that the buyer owes their own broker. And so the buyer and the buyer's broker will have to have a discussion about whether to even ask for this amount, because if you're going to force the seller into a counteroffer situation, that may not be the best strategic approach to a transaction. So it's something that needs to be discussed between the buyer and the buyer's broker. And this is the form that would be used in that situation. So let's pop on back to the residential purchase agreement, and we'll see some other issues that have come up. So here we're still in the grid. We're looking at paragraph 3M3 of the grid. And what does this have to do with? It has to do with the tenant occupied property addendum. This is the paragraph that addresses a situation where the seller's property is occupied by somebody other than the seller. And when C.A.R. changed its form in 2021, we created a new form called the Tenant Occupied Property Addendum, TOPA, that really should have been used anytime the property was tenant occupied or occupied by anyone other than the seller. What we found over the course of the year was not everybody was bringing that form into the transaction when it should have been brought in. And when the TOPA was not brought into the transaction, the problem that created was you did not know what happened with the existing tenant. You did not know what the buyer was agreeing to or what the seller was agreeing to. So we said we need to correct that issue. And the December 2022 version of the C.A.R. form does address that issue. It requires the seller to disclose if the property is tenant occupied. Now, for the purpose of our forms, for the purpose of this contract, for the purpose of the TOPA, tenant means anyone in the property, any adult in the property other than the seller. So it could be a parent of the seller. It could be an adult child of the seller. Tenant means anyone other than the seller, any adult other than the seller. It's presumed if you're a seller and you have minor children, you're going to be taking your minor children with you. But that may not necessarily be the case with an adult who's living on the property. So just remember that for this purpose, tenant means any adult living on the property who is not the seller, okay? So seller, you are obligated to disclose to the buyer if there is a tenant on the property, okay? Seller, you are obligated to deliver the property vacant, or if it's more than one unit, if you have 2 to 4 units. Buyer, you have to identify which unit you want to be vacant. And seller, you have an obligation to deliver that property vacant. So seller, now it is incumbent upon you to bring the TOPA into the transaction. What does the TOPA form do? The default provision in the TOPA says, buyer, you are taking subject to the rights of the existing tenant. That means they get to stay there. There's an optional paragraph that says, no, the tenants will be removed. There is a recognition for that optional paragraph that if the seller is not able to remove the tenant after making a good faith attempt by applying California law, then the buyer's remedies are limited. The buyer could either cancel and say, I don't want the property, seller, since you could not get the tenant out. And in the event the buyer says that, the buyer is entitled to a reimbursement of all of their out-of-pocket expenses. Or the buyer could say, you know what, I'm willing to take the property with the tenant in the property, and I'll worry about getting the tenant out on my own. So very important, we really emphasize that you need to use that TOPA anytime you have a tenant-occupied property that's being sold. Another quick clarification in the home warranty paragraph 3Q18. We already know from the prior version of the contract that it's the buyer who chooses the home warranty, it's the buyer who chooses the coverage. But what if you said that the seller was going to pay for all or part of that in that sort of middle column there? Well, the last column says, seller, if you have an amount that you're going to pay, so you're going to pay for all of it, or you're going to pay for a portion, maybe you're going to split the cost with the buyer. It's the seller's cost that is limited. The seller's cost cannot exceed a certain dollar amount. Buyer, if you choose an expensive policy with lots and lots of optional coverage, that's fine, but the seller does not have to pay for that. Buyer, you're the one who's choosing the company. You're the one who's choosing the coverage. Buyer, you should be the one who's aware of what it costs, and therefore you would have to pay for any amount over and above what the seller's cap is going to be. All right, let's move on to our next big RPA paragraph. It is the assignment paragraph. And you can see in the title of the assignment paragraph that it's now called assignment and nomination. And the reason we added that extra name to the title is our members were telling us that they still see written into contracts. For example, at page 1, they would see the name of a buyer, and sometimes it would say buyer or nominee. Well, there's a legal difference between an assignee and a nominee. And actually using a nominee is very problematic from a strict legal standpoint, okay? And so we don't want to see that. But how can we prevent somebody from writing something in that seems to be done out of habit in the real estate industry? And so our answer to that at C.A.R. Standard Forms was, you know what, we're going to say for the purpose of this contract, if somebody writes in the word nominee, what they really mean is assignee, and that there's going to be no contractual difference between an assignee and a nominee. They're going to be treated exactly the same. And that's the language that was added to the bottom of paragraph 23 of the residential purchase agreement. And what do you know? I'm already down to the last page of the RPA, and this is the agent signature page. And there was a bigger section that used to be there before December of last year called designated electronic delivery address. So we know, right? We know parties out in the field almost exclusively send documents electronically. They send them through zip form, they send them through email, right? And so the previous year, we addressed that situation that said, if you identify an electronic address, whether it's an email address or a phone number for sending text, then that document is deemed to be delivered as soon as it is sent to an identified address. And that section in the broker's signature page took up a lot more room than it does now. But what C.A.R. missed was we did not have contact information for the buyer side broker and the seller side broker. So in the updated RPA, we included the contact information for the buyer's brokerage firm and the seller's brokerage firm. And because we did that, we were able to simplify the designated electronic delivery address small section within it. So you're either going to use the email above or the text to the phone number above, or you're going to put in an alternate. And why might you want to put in an alternate? A very good example. You are an agent working for a brokerage company. Maybe you do not want information sent to the brokerage company email address. You want information sent to your own agent email address. And so that's why you would fill in that DEDA, designated electronic delivery address paragraph. You can sort of see in that, hopefully you can see in that blue box on the right side of your screen, I talked about nominee and assignee, and C.A.R. created a quick guide to talk about what the differences are from a legal perspective. And quick guides are basically one-page documents, sort of like a very short Q&A, and you can find that by, copying and pasting that link into your browser. Were there other changes made to the RPA? Absolutely, there were other changes. I listed them out here on this slide, so you can take a look and see some of the other things that might be relevant. One of them that certainly is important given our new form, the C.A.R. form, SOLAR, the solar form, is that paragraph 11, which is the disclosure paragraph, now requires the seller to fill out a questionnaire addressing issues that arise with solar panel systems. So again, for those who want to see some of these other changes, they're here on your slide. And this perfectly leads us into the new forms. The first one is the solar advisory questionnaire, and the other one is a non-contingent offer and advisory. We were kind of concerned when we created the non-contingent offer advisory, non-contingent offer advisory, that because the market shifted this year, that maybe there really wouldn't be a need for this right now. But I tell you, I've been giving speeches throughout the state of California, and there's plenty of areas in the state where there still are non-contingent offers being written. There are areas of the state where there's still multiple offers on properties. So actually, it looks like there could be continued use or interest in the non-contingent offer advisory. Let's take a look at these two forms. The first one is the solar advisory and questionnaire. It's a 2-page form. The first page is really just informational. The first page is an advisory. It lets buyers and sellers know what's involved with a solar panel system. Because a lot of people, even those people who are selling the system, they really know nothing at all about what a solar panel system is, what it does, how ownership works, whether there's a lease, whether there's a lien, whether there's amount owing, whether there's no amount owing. And so the first page is there to give both buyer and the seller some general information about solar ownership and the way these things work. Oh, I skipped a little bit, sorry about that. This is still the first page, and ultimately it comes down to who is going to decide what to do with the solar panel system, whether it's a good idea to purchase it, how much to pay for it, etc. And we had to include paragraph 5 because it's really not the broker's decision. Broker, you give buyer's information, but ultimately it's the buyer's decision, and the buyer would need to investigate to decide the advantages of purchasing a property with a solar panel system. Page 2 of this form is more like a seller property questionnaire, or more like a transfer disclosure statement. The seller is asked specific questions. Seller, are you aware of things? Now, already in the RPA, there's a requirement for the seller to deliver documents related to a solar panel system on the property. But that could be a huge stack of information that's provided to the buyer. The buyer really wants to know some key things, right? So if we look at paragraph 6, how old is the solar system? What's the name of the installation company? What's the size of the system? How many panels? How many kilowatts are being provided? Is there a battery bank or a power wall? Things that are very important issues for a buyer to want to know about. And then either paragraph 6B or 6C will be filled out, but not both, because either the seller owns the system or the seller is leasing the system. The seller is not both owning and leasing the system, at least not from what I could tell. It's usually not a combination of the two. It's either owned or it's leased. And then there's information. Is there financing? How much is owed on the financing? And issues like that. So page 2, right, is really crucial for the solar form because it is giving buyer essential information. And again, like the seller property questionnaire, does the seller have to go out and learn information to answer the questions? No. It's asking the seller, are you aware of these things? The non-contingent offer advisory, in a sense, is similar to another form that C.A.R. already has in its library that was called the market condition advisory. And the market condition advisory basically said what? The market condition advisory said, hey, values go up and values go down. Brokers not guaranteeing that the value of the property as purchased is going to stay the same. But given the hugely strong seller's market that we had going for about 2 years, where buyers essentially needed to write non-contingent offers in order to get their offer accepted, buyers were doing so and maybe were not aware of the risks that they were taking by doing so. And so we created a specific non-contingent offer advisory that gives the buyer information, right? And we look at that top sort of yellow highlight. Well, making a contingent-free offer may give the buyer a better chance of getting a seller to accept the offer. There are risks in writing such offer. And we talk about the risks of not having a loan contingency, not having an appraisal contingency, not having an investigation contingency. And ultimately, it comes down to a broker recommendation, which is buyer, these contingencies are for your benefit. You have to balance whether it's worth taking the risk of writing an offer without those contingencies. Buyer, you may say it's worth taking that risk because you want the property badly enough. But the key is the buyer, you're making an informed decision. Let's take a look at a couple of the other revised forms. Here we're dealing with the counteroffers, the same change in all 3 C.A.R. counteroffer forms: seller counteroffer, seller multiple counteroffer, and buyer counteroffer, right? So in all those counteroffers, there are a few paragraphs that precede the blank lines. And these few paragraphs apply anytime a counteroffer form is used. So the first paragraph A says, guess what? Liquidated damages and arbitration, they're not included if they're only initialed by one person. They need to be initialed by both, or they need to be referenced in the counteroffer specifically. Paragraph B says, well, we know counteroffers often change purchase price. What effect does that have on down payment and loan amounts? And so the automatic provision, the default provision is that the down payment and loan amount will be adjusted in the same proportion as in the original offer. but a deposit amount is not adjusted. And a credit that was put in for the seller to pay in the purchase offer, that is not adjusted proportionally either. So down payment, loan amounts get adjusted, but deposit amounts and credits do not automatically get adjusted. And then we dealt with the third issue. So when C.A.R. revised the purchase agreement in 2021, we included, we included a paragraph in the appraisal contingency that allowed a buyer to say to the seller, you know what, I will reduce my appraisal contingency amount to something less than the purchase price. So the buyer would be telling the seller, hey seller, and I'm just going to use, I'm just going to pick, just an easy number to use. Let's say the purchase price was $1 million. The buyer could tell the seller, as long as the property appraises at $950,000, okay, I would not have the right to exercise my appraisal contingency, right? So why would buyers do that? Well, because in the fast-moving market, appraisals were not keeping up with market value. So the buyer may say, as long as I get an appraisal of at least this amount, okay, then my appraisal contingency has been satisfied. Well, that's all fine and good if the purchase price never changes. But what if the seller changes the purchase price from $1 million to $1,100,000? Does that mean that the appraisal contingency amount stays the same at $950? Or is it adjusted proportionally? Or is there some other kind of mechanism in place that would need to be addressed? Well, the old version of the contract did not say what would happen if the purchase price changes. Paragraph 1C that has been added to all the counteroffers does say what happens. And what it says is that differential between the purchase price and the appraisal contingency amount, that will stay the same no matter what the ultimate purchase price would be. So in my original example, $1 million offer, $950,000 appraisal contingency, counter offer at $1,100,000. What that means is that the new appraisal contingency amount would be $1,050,000. So you take that new purchase price, you take out that differential that existed in the original offer, and that gives you your new appraisal contingency amount. Wrote it down here. Not really that complicated. It was a little bit difficult to write. So writing it out, I think, makes it sound a lot worse than it is. But just look at the bottom part of the screen, and I think everybody could figure that one out. And again, most offers do not have a reduced appraisal contingency amount. So paragraph 1C is not going to impact most of you most of the time. What about the cancellation of contract? This is just a reminder, right? The cancellation of contract is really two forms in one. The first part, paragraph 1, addresses canceling the contract. You can have a unilateral cancellation of contract, but paragraph 2 deals with canceling escrow and returning the deposit. That must be mutual. So here you see in the highlighted paragraph, we just wanted to make clear that for a cancellation, you could either have a buyer or a seller signature, as long as they're exercising a cancellation right under the contract, right? So how can you cancel a contract unilaterally? And the answer, I think, is something that you all already know, right? So what do you know? Buyer, if your contingency fails, you have the unilateral right to cancel. You don't need the seller's permission. And seller, if the buyer does not remove contingencies and you issue a buyer notice to perform and the buyer still does not perform, seller, you then have a unilateral right to cancel. Or maybe there's a proposed mutual cancellation. So that's all that was done for the cancellation of contract form. Then we came out with this suite of 6 buyer representation forms. So I already showed you one of them, the seller's payment for buyer's broker, SPBB. But the big change was we consolidated 3 forms into one. So we used to have 3 buyer broker forms, an exclusive, a non-exclusive, and a not for compensation. Now we just have one buyer representation form. It's called the BRBC, Buyer Representation and Broker Compensation Agreement. It defaults to a non-exclusive, but can optionally be made exclusive. We'll see quickly what that means in just a moment. Okay, but there's just one form to use to enter into a contractual relationship between a buyer and the buyer's broker. We had to come out with some other new forms, right? Our favorite code now is Form ABCD, Anticipated Broker Compensation Disclosure. We talked about the SPBB already. There's the possibility of canceling the buyer representation agreement. So it came out with a form to allow that to be accomplished. If the broker has shown properties to the buyer and wants to protect the broker's right to be paid, the broker needs to give a list of those properties to the buyer. That's notice of broker involved property. And then there's a buyer transactional advisory that's already bundled with or pre-attached to the buyer representation agreement. We have an entire 1-hour webinar just on these forms. I encourage you to look at it. You go to C.A.R.org, go to transactions, look for the transactions tab. Then you go to risk management, then go to legal live webinars. Those of you who are going to be getting a copy of this presentation, on the second slide, I have the actual link, so you can just copy and paste that into your browser. An entire 1 hour just on these buyer representation forms. But let's kind of go over a few of the highlights. So the first thing is, in the past, agents we know are afraid to ask buyers to sign a buyer representation agreement. Agents find it scary. Agents think the buyers find it scary. What I'm going to tell you is this whole new suite of forms, it's not so scary. It's sort of like these are the Casper the Friendly Ghost version of buyer representation. There's a lot of things that I think, if they're explained to a buyer, will show the buyer that there's really nothing to worry about with the use of these buyer representation forms, and gives you as a licensee an opportunity to really sell yourself. So let's start with the buyer representation and broker compensation agreement. Is there a set length of time? No, just like the listing agreement is not for a set length of time. But if you look at paragraph 1, we have a beginning date, but we don't have an ending date. You're going to have to put in how many days this buyer representation agreement is going to last. Why do I have my little friendly ghost there? Because you don't have to start with a 365-day buyer representation agreement. You don't have to start with, a 90-day buyer representation agreement. Why don't you see if you and a buyer are compatible with each other? You can do 1 month, you can do 1 week. I have a broker who tells me they start off with a 1-day buyer representation agreement, and they just extend it if they find out that they're compatible with the buyer and they're both working towards the same end. So don't make it scary, make it friendly. What are some other things? Well, when we go to paragraph 4B, the default is 4B1, meaning this is a non-exclusive representation agreement. What does that mean? Why should that not worry a buyer so much? What the non-exclusive says is brokers telling the buyer, you only owe me compensation for properties for which I have been involved in, meaning I've shown you the property virtually, I have shown you the property in person, or I've written an offer on a property for you, or I've done some other activity specifically related to this property. Merely sending a list of available properties, merely sending links to showings or virtual showings of the property, that's not enough. Basically, the explanation for the buyer is, wait, if I've done the work, buyer, don't you think it's fair that I'm entitled to be paid? If somebody else has shown you the property, somebody else did all the work, then they're entitled to be paid. The non-exclusive is really not that intimidating. Now, there's a lot of brokers They don't like the non-exclusive. They say, if I'm putting work in, I'm putting my time, blood, sweat, tears into finding buyer a property. If the buyer finds anything that fits within their parameters, I think I should be paid. That would be the exclusive. That is optional. That's 4B2. The other thing that I think is very friendly for a buyer is, guess what? This agreement is cancelable by either one of us at any time. And if it's canceled, and I've already shown you properties, or I was already involved with you for certain properties, I will give you a list of those properties, and I will be entitled. But otherwise, our relationship is terminated as of the date of the cancellation. If you like having an exclusive relationship, the cancellation requires 30 days notice. Paragraph 4D, buyer. One reason you don't have to worry so much, buyer, is even though you're agreeing to pay me, if I get paid through somebody else, usually the listing agent, through an offer of compensation in the MLS, then that is, you are given a full credit for any amount that I get paid from somebody else in the transaction. Okay. Paragraph 4F talks about basically this new form, the ABCD form. It basically says, buyer, I'm going to disclose to you how much I anticipate getting paid for each particular property. And then after the transaction, I will disclose to you how much I actually did get paid. And here's that ABCD form. It's broken out into 3 parts. That middle part is the property by property anticipation of compensation through the MLS. Do you need to use our ABCD form? The answer is no. Your MLS may have a form, a non-confidential form that can be given to the buyer showing the offered compensation through the MLS. And if you do that on a property by property basis, you do not need to use the C.A.R. ABCD form. Again, either party can cancel. We have a cancellation form. If you want to make your buyer feel good, give them the cancellation form when you sign up a buyer representation agreement. Say, buyer, here it is. Anytime you want to cancel, all you have to do is fill it out and bring it back to me. I know some brokers don't even want to discuss that issue up front, but it may make the buyer feel comfortable knowing that you're telling the buyer that they can get out and that their only obligation is for properties that you've already been involved with them prior to the cancellation. Signature blocks here, there's some other options that might be applicable. You'll have to decide whether the other options are appropriate. This form, NBIP, is where the broker has to give the buyer that list of properties that have already been shown, essentially, right, or involved with. And if the buyer representation agreement just terminates automatically, then this NBIP form has to be given upon the termination. If either side cancels the buyer representation agreement, then the broker has 5 days to give this form to the buyer. Then the broker has 5 days to give this form to the buyer. Just some more information about agency here. We discussed that form already. Many property management forms have been revised. The only one I want to talk to you about is the rental property owner disclosure. Here's where the owner of the property gives information. This form, as it currently exists, is designed to be given by the property owner to the brokerage at the time of a lease listing or a property management agreement. This form is being split up into 2 forms for a June release this year. And the new rental property owner disclosure will be given to both the brokerage company and the tenant. But for now, this form is intended to be given only to the brokerage company and not the tenant. Wow, okay, 11:20, done just in time. So I think maybe I'll stop sharing my screen, but actually before I do, I want to see, I'm going to go way back to the beginning, just in case somebody wants to write it down, how to access those other webinars we have. And here they are. So we've got 3 webinars, one just on the property management form, one just on the buyer representation form, and a more extensive one discussing the RPA and the related form changes. They were all done in January. So you see, you got www.car.org, EN, risk management, and live, and you can find any of those 3 webinars there. Again, I'm going to make these slides available, and anyone who wants them can just request them from your AE. There we go. Why don't we go into some questions? Do we?
All
Maybe
right.
we don't have any questions. Okay.
I am not seeing any questions, and this is a good time to remind those of us who are watching to use the Q&A feature. So it does not appear that we have any questions and answers. I see a raised hand.
Yeah, one raised hand.
Okay, so why don't we take it that way?
Let's try that.
Okay.
There you go. All right, Marilyn, you're good to go. Just unmute yourself.
There I am. Can you hear me now?
We can hear you.
Yes, we can.
I was just in a Coldwell Banker office meeting before this meeting where 2 members, 2 realtors in our office were talking about the new Fairfax and rent control situation. And I know you're very familiar with it, Romeo, but that non-tenant occupancy or tenant occupancy form, anybody in Marin County that is dealing with any of this, it could be a very, very important form, because those tenant rules were terrible. Excuse me.
Well, so I'm glad you raised the issue, Marilyn. I'm not familiar with the local issue, but when C.A.R. standard forms created the tenant occupied property addendum in December 2021, it was very important for us to address the 2 primary issues, which is, first, is the buyer taking the property subject to the tenant's rights, right? And so that's the default provision. If there's a tenant in there and the new RPA, right, the default is the burden is on the seller to make the disclosure. If the seller does not make the disclosure, if the seller does not provide the TOPA, then the seller is contracting for a vacant property to be delivered to the buyer. But assuming the seller knows if the property is tenant occupied or occupied by anyone other than the seller, any adult other than the seller entitled, then it's important to get that TOPA form into the transaction. Okay, the default is buyer, now you're being put on notice. Maybe the seller includes this in a counteroffer. Buyer, you're being put on notice under the default that you're taking subject to the tenant's rights. But if we do not use the default, we use the optional paragraph that the property is to be vacant. C.A.R. recognized that it is so difficult to remove tenants no matter where you are in the state, whether there's rent control, whether there's eviction control or not, because there's statewide rules that impact removing a tenant as well. That's why we built in that option that if the seller, after making a good faith attempt to remove the tenant, is not able to do so, the buyer has only 2 choices at that point. Take the property with the tenant or cancel and get your out-of-pocket costs back. That's the recognition of the reality of owning tenant-occupied property in California. So thank you for bringing that up.
So we have right now 2 more questions.
Okay.
Joe has a question. After an offer is accepted and in contract, is there any need to go back and complete a DEDA?
I'm sorry, I was reading something, so I missed the beginning of what you said. I apologize.
So Joe Burns said, after an offer is accepted and in contract, is there any need to go back and complete a DEDA?
Well, if the DEDA, the purpose of that is to allow delivery of documents electronically and to figure out when they are effective. So they are effective when sent. If the DEDA paragraph was not filled out on the last page of the purchase agreement, then my recommendation would be use the addendum. We actually have a DEDA addendum where now you can address what the electronic method of delivery will be. So I think it's a good idea because the reality in California is there is almost no in-person delivery of documents anymore. That has long been surpassed by electronic delivery of documents. So the issue is, was that paragraph completed in the RPA or not? Okay.
All right, thank you. And Sherry Faber, she has a question. She basically says she missed the ABCD presentation. She was wondering if we are now obligated to disclose buyer our compensation. If so, why? Seller pays the commission 90% of the time.
Right. Seller most of the time does pay compensation. But what has always been the case under California law is that brokerages, so a broker or an agent, cannot collect secret profits. So what does that mean? You have to disclose to your client the compensation that you are receiving for acting as a broker or agent in the transaction. That's always been the case. So the purpose of either using the ABCD or providing the MLS printout page showing compensation is that you are having full transparency with your buyer. Over the last couple of years, there have been some lawsuits at the national and certain state levels and involving brokerages that have put brokerages at risk when they have not had this discussion with their buyer clients about how much they were getting paid for transactions. So this puts everything out in the open. Even if there is no buyer representation agreement, that does not matter. The client is still informed that the buyer's broker is receiving compensation for performing their services. That's the value of doing that.
Thank you, Neil. I have two questions or just comment. One, I believe at the seminar or the meeting, we talk about the fact that sellers should go back and review the disclosures if it's been there before you accept the offer, if it's been on the market for a while. And the other thing is wondering if you anticipate any more phone updates this year.
Okay, great. So the issue about seller updating disclosures has to do with the situation that we're currently in, which is properties are not selling as rapidly as they were, a few months ago or a year ago, right? And so if a seller completed their disclosures at the time of taking a listing, those disclosures may be outdated or there may be new circumstances that require a change once an offer comes in that is being accepted. And so the advice is, seller, upon accepting an offer, you should review all of your disclosures to make sure there has been no change. And if there is a change, to either update that disclosure or use the addendum form, check a box indicating that you are making an addendum to the previously filled out transfer disclosure or seller property questionnaire. Why? Because you do not want a material fact to be undiscovered or undisclosed. The second issue is, what about changes to C.A.R. forms? C.A.R. changes their forms twice a year, in June and in December. So yes, we are planning on having a forms release with new and revised forms at both of those times in June and December of this year.
Great, thank you very much for coming. Sounds like we have to invite you to come back after June.
Happy to do so.
Yeah, thank you for your information. I hope attendees find it very helpful. And like we say, we're going to have follow-up updates on the phones. And if you have any questions you'd like to cover in a speaker series, please let me know or send it to Romeo. And final thank you to our sponsor, Hikaru Rasuli. She is the Mutual Omaha Reverse Mortgage Specialist. And I want to thank our MAR staff for setting up the speaker series and supporting us all the time. And please sign up for our next general membership meeting with Bill Jensen on Tuesday, March 7th. And of course, I mentioned that before, don't forget May 3rd, California Legislative Day in Sacramento. If you've never been there, it's a very exciting day. Come join us. So thank you and have a wonderful day. Happy Valentine's.
Happy Valentine's.
Thank you.